2015. The regular meeting of the Planning and Zoning Board will come to order. Preliminary matters.
Staff has no changes or additions.
No, how about any member of staff and the board? Approval of minutes, regular minutes from August 6th.
I just had one question on page 2. Mr. Daig wanted to make sure that the word expensed is used. I'm wondering if it shouldn't have been dispensed. That's on the medical marijuana that we discussed. I don't know, that would be, Mr. Daig wanted to make sure that this ordinance states the only way it can be expensed is by smoking only. I think that word should have been dispensed. Is that what your intent was? Did you say that? Then that would be my only correction.
Mr. Chair, I'm fine with that.
Thank you. Anybody else have any additions or corrections? Other than addition, the one change we've made to it, all in favor of accepting the minutes?
Yes.
Okay, minutes are approved. Should we, Wayne, I'm going to open for still public comment right now for...
Sure,
yes.
for general public
The
comment.
general public will not be able to speak during the two issues that we have today on the agenda, but you can speak now. So if you'd like to come forward before this board and speak, please come forward now, and so we can hear anything you have to say. So public comment is open. Seeing nobody coming forward, I'm closing public comment. Okay, there are two items on the agenda today. I'm going to read both applications. There's an A and a B. Application A 15-00002 is submitted by the law firm of Rooney & Rooney, appealing the Planning and Development Director's interpretation of the city code pertaining to the guest house and transient quarters. Also, today, item B is application A 15-00003, submitted by the law firm of Rooney & Rooney, appealing the Planning and Development Director's interpretation of the city code pertaining to guest houses and transient quarters. Because both parties have agreed, we're going to combine those, but it has been recommended that the author of this request has the right to make additional comments at the end in regard to both items. Is that agreed upon by both parties?
Yes, Chairman. That's correct, yes.
Okay. And both of you are representing the applicant?
I'm the only one representing.
Okay.
Yeah, this is Nick, if you haven't met him before, and I'll let him say his last name.
Okay.
Nick Zabresny, and I'm here on behalf of Mr. Vero.
Zabresny, okay. Nick Zabresny, okay.
B.
The second item we have before we start there is this disclosure by the Planning and Zoning Board members of any ex parte communications. Does anybody have any ex parte communications?
No, sir. No.
I have none.
Seeing none. Swearing of parties and other potential witnesses by the clerk. Tammy?
If you're going to testify, if you just raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All custody of exhibits will be maintained by the city clerk, so we have that in mind. And the appellant, you can make your presentation now. Matter of fact, this is one of the very few of these we do, so it's going to be a little rough in the procedure, so you correct me if I make any missteps, will you?
Oh, that's okay.
All right.
I appreciate you taking the time to hear my arguments today. I'm from the law firm Rooney & Rooney. My name is Jonathan Rodeback. I represent the appellants in this case. There's two separate cases. One, Charles Fitz, and the other one is Kent Wagner, Charles Wagner, and Gabriella Wagner. I have two separate packets here. I made 5 copies because I figured there'd be 5 of you today. I wanted to present to you. They're not really evidence or exhibits, but they are in fact copies of citations, the statutes and relevant provisions of the code, at least so I can walk you through the arguments today. If you'd like me to pass that up to each of you, that would be whatever your procedure is.
Thank you, yes.
Sure, why don't you just give Mr. Cahoy at the end, and he can pass them down if you like.
Okay. paperclip. The first one will be for
The overhead.
Charles Fitz.
Is that what we have here in front of us already? I hope it is.
This is separate from the backup that we received.
Is this in addition to, or, you know?
You have a copy of our administrative appeal, which I believe is brief. You also have a copy, according to your agenda, of our letter in response to Tim McGarry's interpretation. These
Can you-
specifically are just copies of the citations themselves and the relevant code provisions and statutes that are referenced in Tim McGarry's interpretation and our briefs. That's all.
You may have to speak into a microphone.
Right, because
for us
we're not
also.
picking you up.
You're not picking
No,
me up?
sir.
Do you want me to go back?
If you're going to be away from the podium, there is a portable microphone in the drawer there that you can turn on.
Technology isn't a strong suit, so that can make things a little interesting.
Sure.
What I was trying to say, essentially, is that you are in possession of our brief for the administrative appeal, Tim McGarry's official interpretation, basically his decision on our administrative appeal, and then our letter that brought it before you in response to his official interpretation. What I am passing to you now are copies of the relevant citations that were issued to our clients and also relevant code provisions and some of the sections of the Florida statute which were referenced in Tim McGarry's official interpretation and in our briefs submitted in support of our argument. It's not really evidence. It's a matter of public record. Any of you could go on Google, type it in, and find it. It is just to assist you as I walk you through my arguments today. Does that provide clarification? Okay.
Yes. This is B for us. That's A, and this is B. All right.
The paper clips, the first ones I passed you pertain to the Charles Fitz appeal. The second packet you got paper clipped as well is for the Kent Wagner, Charles Wagner, and Gabriella Wagner. The only difference between the two are the citations involved.
A and B, there should be a number.
Sorry, the fan was going into the broadcast. So you could hear.
Please let me know when I'm ready.
We're ready? Yes.
All right.
Proceed.
Until I state otherwise, everything I talk about pertains to both appeals. It'll just be, it's mainly the same argument. There's just one important substantive difference that I'll mention at the end. But the first thing I want to reference is the fact that I object to this very hearing going forward. And the reason why I object to it is if you take a look at in your packets, Section 2-303 of the Vero Beach Municipal Code of Ordinances discusses an appeal of a interpretation or application of a code provision within the Vero Beach Municipal Code of Ordinances. It goes to what is referred to as the designated administrative authority. The designated administrative authority is defined in 2-303 subsection S for the purposes of this article, and I'm reading it aloud. Designated administrative authority means the city official, department head or director, or his designee, having jurisdiction and responsibility for administration of the code, ordinance, rule, or regulation. If you'll notice, it doesn't say and, it doesn't say to the planning and zoning director, then to the planning and zoning department, to the board, to the city council, etc. What happened in this particular case is what's being interpreted is 64.04 of the Vero Beach Municipal Code, which deals with appeals of decisions made pursuant to Part 3 of the Vero Beach Municipal Code of Ordinances are supposed to go to you. The issue is that this is not an appeal pursuant to Part 3 of the Vero Beach Municipal Code of Ordinances. This is an appeal of a designated administrative authority's decision pursuant to 2-303 of the City of Vero Beach's Code. Tim McGarry, the designated administrative authority, pursuant to the 2-303, is supposed to render a decision, and then it is supposed to go back to the Code Enforcement Board to make a decision, which could then be appealed up the chain. There has been a tacking on of the interpretation, the application appeal process of 64-04, and I'm sorry, not 64-04, 64.04 of the code, where it goes from Tim McGarry to you. So for that basis alone, I think this entire process, this entire hearing, I object going forward. But that doesn't, moving on to basically the substance of our arguments, the ordinance or the restriction on, quote, guest house and transient quarters that exist in this city is unconstitutionally vague and unenforceably vague. The vagueness test, as determined by the Florida courts, is whether a statute or ordinance gives a person of ordinary intelligence fair notice of what constitutes forbidden conduct. In this particular case, no person of ordinary intelligence has fair notice of what constitutes what this forbidden guest house and transient quarters is that is supposedly forbidden in residential zoning districts. If you go to the Vero Beach Municipal Code of Ordinances and look at the definitions, and in those definitions, it defines guest house and transient quarters as follows. Any structure, including converted dwellings in which less than 10 bedrooms, with or without meals, is rented or otherwise provided for compensation to transients for their temporary care and lodging. A transient is defined as a guest and transient occupancy. It doesn't provide any more clarification, so you have to go to the definition of transient occupancy. Transient occupancy, as defined by the City of Vero Beach Municipal Code of Ordinances, is any occupancy for which it is the intention of the parties that the guest's occupancy will be temporary. The word temporary is not defined. Essentially, in summary of what I just said, the City of Vero Beach is regulating guest house and transient quarters, which is renting a property to a transient. A transient is someone in transient occupancy, and transient occupancy is an occupancy for which it is the intention of the parties that the guest occupancy will be temporary. I want you to think in your minds what and how you define the word temporary. That can mean 30 days, 60 days, 90 days, 2 years, anything less than permanent. In fact, Tim McGarry, in his official interpretation, defined it as just that, not permanent. So that means 10 years could theoretically be temporary within the Vero Beach Municipal Code of Ordinances, which would constitute a guest house and transient quarters, which is not allowed. There is a teeny tiny little bit of guidance given in the code about what Tim McGarry or what the City of Vero Beach means by the word temporary, and that is there is a rebuttable presumption that if a structure or property is rented to guests for periods of less than 30 days or 1 calendar month, whichever is less than its transient occupancy. But that only creates a rebuttable presumption. It's not per se transient occupancy. In fact, there's nothing in the code that says it can exceed 30 days or it can even be less than 30 days. In fact, the code doesn't even tell you how to rebut the presumption that a particular occupancy is transient. Given the wide range of the definitions that could theoretically exist for the word temporary, 30 days, 60 days, 90 days, 10 years, whichever it may be, no person of ordinary intelligence can read the City of Vero Beach Municipal Code of Ordinance and know what it is that they're allowed to do with respect to renting their property. Now, moving on. There's also the issue of arbitrary and discriminatory enforcement. It's not just the citizens of Vero Beach who have confusion regarding how long they can rent their particular property. It's the code enforcement officers, the people charged with enforcing the code, that are going to have the difficulty as well. The code enforcement board, who must make a determination of whether somebody's operating a guest house and transient quarters, which means they're renting it to somebody on a temporary basis. Make no mistake, that's what the code says. If they're renting it to somebody on a temporary basis, it'll be up to the code enforcement board and the code enforcement officer to decide whether to cite this person $500 per day. It provides no guidance, not sufficient guidance. That way you can make a determination whether you can comply with the code, whether you're acting in contravention of the code, whether you're going to be cited, or whether you're acting appropriately. Now, Tim McGarry, in his interpretation, he references Section 509.013, subsection 4A of the Florida statutes in an effort to bolster his interpretation of the word transient. I'll take a second to let you guys flip through your packet. That way you can get 509.013. I've printed that out for you. If anybody's having a tough time finding it, the Florida Senate in the top left-hand corner will be a good way to find it. Taking a look at the definition by the state of Florida, transient public lodging establishment. That's the reference Tim McGarry made in his official interpretation to justify the 30 days or less interpretation of the word transient or temporary. It states, and I quote, reading off the definition, transient public lodging establishment means any unit, group of units, dwelling, building, or group of buildings within a single complex of buildings which is rented to guests more than 3 times in a calendar year for periods of less than 30 days or 1 calendar month, whichever is less. The important distinction between what Tim McGarry's interpretation is and what I just said is that you'll notice in the Vero Beach Municipal Code of Ordinances, there's no reference whatsoever to renting your property more than 3 times in a particular year. Rather, it's 30 days or less. If you rent it one time for 30 days or less, it's a prohibited guest house and transient quarters. The state of Florida determined that it has to be 3 times in 1 calendar year for it to be of this transient nature, which Tim McGarry is stating. Even if you disagree with my arguments as they pertain to the vagueness of the statute, or, I'm sorry, not the statute, the ordinance, this ordinance has been preempted by state law. In that packet, I also provided you a copy of Section 509.032. If you go to that, actually, you might not have a copy of that. I do. No, you do. You do. If you go to Section 7B of that particular statute, Section 509.032, subsection 7B states, a local law, ordinance, or regulation may not prohibit vacation rentals or regulate the duration or frequency of vacation rentals unless such local law, ordinance, or regulation was adopted on or before June 1st, 2011. The applicable definitions and applicable code provisions were amended by Ordinance Number 2015-02. That is 2015. I don't think anybody would disagree with me that 2015 is after June 1st, 2011. The state has expressly preempted this, which is a legalese way of saying the state says, local governments, you can't do this. That is all it's saying in a nutshell. So on that basis alone, Ordinance number 2015-02, which defines guest house and transient quarters and transient occupancy, should be stricken because it attempts to regulate vacation rentals, which the state specifically says this city is not allowed to do. Now, Tim McGarry said in his official interpretation that the city has been banning guest house and transient quarters since the 1980s, or for 30 years or so. However, if you look at the ordinance, pre-2015 ordinance, and you take a look at this code, the word transient was never defined. There was never a cross-reference to 509.013, which is this definition of transient that the state legislature made. In fact, this city even attempted to enforce, on one occasion, this particular ban on guest house and transient quarters back in 2013. It is the City of Vero Beach versus John and Tracy Carroll case. I'm sure some of you might have heard of it. The Code Enforcement Board determined that the ban was too vague. It was appealed to the Circuit Court Appellate Division, and it was affirmed per curiam. So, you already tried to fight this issue once. There's no reason to fight it again. It was not banned. It was too vague. It was unenforceable prior to this ordinance, and that's why 2015 ordinance was enacted. Unfortunately for the City of Vero Beach, it was enacted in the express violation of state law, which says, local governments, you cannot do this. Now, I had a whole bunch of other arguments as it pertained to the First Amendment and of impermissible delegation of legislative authority to a non-elected official. I put those in my brief, which I'm hoping you read beforehand. I can either get into those arguments with you or make my arguments to you, or I can rest on the merits of the brief that I wrote. It tends to get a little convoluted and a little complex. I think my two main arguments were set forth pretty clear, so I'll leave it up to you whether that's something you'd like to hear arguments on the First Amendment issue and the impermissible delegation of legislative authority to a non-elected official. That's up to you guys.
Members?
Yeah, I mean, I'm used to seeing administrative permits and decisions made in local governments here in the state of Florida. Are you saying it's unconstitutional?
Well, at least with respect to how it violates the First Amendment, there's a bunch of other constitutional arguments as well that I already set forth, though unconstitutionally vague, and the state preemption. These ones deal with kind of the nuances of the First Amendment and the impermissible delegation. Why don't I touch upon those briefly?
I was going to suggest, Mr. Chairman, you probably should go ahead and make your record. You can certainly make your filings part of the record, but it's your call. Really, it's not their call, because they may very well have questions for you later.
Yes.
But you probably, it's up to you what record you want to make.
I understand. I want to read the brief that was submitted in support. Those touch upon the arguments, and I'll just touch upon them briefly. You'll notice in the transient occupancy definition, there's a rebuttable presumption that an occupancy is transient if you advertise or you hold it out to the general public that you regularly rent your property for 30 days or one calendar month, whichever is less. That is an attempt to regulate or restrict somebody's right to free speech, which isn't always permissible. Which isn't always impermissible. There's some circumstances you can do that. In this particular case, however, you are trying to regulate a speech of something that's not necessarily forbidden. You'll notice the words rebuttable presumption. Rebuttable presumption means that, in fact, what you're doing might be legal. There can be a circumstance what you're doing might be legal. Yet the city says that if you advertise this or you hold it out to the general public in such a way, we're going to assume that you have guests in transient occupancy, which is an attempt to regulate free speech. It's impermissible. It violates the First Amendment of the United States Constitution, and therefore should be struck down on that basis alone. Now, my final point that I wanted to make about a impermissible delegation of legislative power to a non-elected official. In this particular case, the city of Vero Beach in section 60.06 decided that if something is not expressly permitted in the city of Vero Beach Municipal Code of Ordinances, it's prohibited, unless the Planning and Development Department Director, Tim McGarry, decides in writing that something is permissible. That means to bypass the entire legislative process, it'll be up to Tim McGarry to decide in writing whether something's allowed or potentially disallowed. That's unconstitutional. We have elected officials. Congress couldn't just delegate all its authority to a judge. Congress couldn't delegate all its authority to Barack Obama. Rather, you can't delegate certain authorities. This is one of them. Determining what's allowed and disallowed in this city is to be determined by the legislature, not Tim McGarry. And for that reason, and all those reasons, the city ordinance number 2015-02 should be ruled unenforceable, and our client should not receive any citations. Nobody should be receiving any citations under this.
Do you have anybody else that's going to speak? You have no witnesses, correct?
No witnesses. It would be improper to have any evidence at this process. The reason being is because we're arguing conclusions of law, essentially. And the Code Enforcement Board is your fact-finding arm of this case, meaning this is going to eventually go back to Code Enforcement Board, theoretically, who's going to determine the facts. I'm not going to bring up a witness for another chance for them to be cross-examined. And similarly, Mr. Zabresny, respectfully, is not going to let Mr. McGarry get up and testify either, unfortunately.
Wayne, do we have a right to ask questions to him now? Should we?
Sure, certainly you could ask him questions and he can decide what he...
Board members, you have questions of the applicant?
There's one thing, and thank you, Matt, that I wanted to touch upon is I told you there was one important distinction between these two cases, and that's the issue with consolidation is sometimes, those issues get oversight, but I appreciate somebody bringing that to my attention. The biggest difference in factual circumstances between the Charles Fitz case and the Kent Wagner, Charles Wagner, and Gabrielle Wagner case is as follows. In both cases, Charles Fitz and the Wagners were cited for violations of Code Sections 60.11, which requires you to act in conformity with the code, and 61.02, which discuss permitted uses within a residential zoning district, or I think it's R1, R2, something along those lines. During the appeal process, the Wagners received an amended citation. That amended citation said that not 60.11 and 61.02, rather 60.06, 61.36, and 61.37. You'll notice it if you take a look at the Wagner's amended citation. The amended citation references an entirely different zoning district in this city. And in the amended citation, it gives the Wagners an opportunity to cure. And the opportunity to cure is April 21st of 2015. There's one huge issue with that. The amended citation wasn't issued until July. So that means the Wagners would have had to invent some type of time travel device to go back in time to comply with the amended citation in order to cure the alleged defect. The issue that I have with is Mr. McGarry respectfully overstepped his bounds in his interpretation. He determined without evidence, because his sole purpose is to determine the interpretation and applicability of the code, he determined that the differences between 61.02, which is a one residential zoning district, which applies to one residential zoning district, and 61.36 and 61.37 is immaterial. Well, it is material, otherwise you wouldn't need to amend the citation. And two, it is an entirely different zoning district. If somebody cites me for violating a particular section of the code, but that particular section of the code doesn't apply to me, how could I ever come into compliance? Therefore, It is material because the amended citation changed the entire applicable sections of the code as they applied to the Wagners and then said you have the right to cure it some date in the past that has already happened. And it is a gross and egregious violation of someone's due process rights. In due process, there's no reason to legalese it. It is notice, fair notice, and an opportunity to be heard. You can't be put on notice if it's retroactively, meaning we're going to give you an opportunity to cure, but by the way, that was you already missed your opportunity many months ago. And that's the only difference between the Charles Fitz case and the Wagner case. And the Wagner case, in addition to those constitutional arguments I made before, it's facially deficient, the Wagner case. Just look at the citation, and the case should be dismissed on that ground alone. The citation, that is.
May I ask a question?
Sure, go ahead.
Okay. You just stated or made the argument that it was the city's interpretation to put out for advertisement to the public on a regular basis. And as I read it here, that is off of the Florida state statute. So it's not just the city making that argument. The state is also claiming that which is advertised or held out to the public as a place regularly rented out to guests. So it's not just the city's interpretation that I am getting this from. It's the state's interpretation. Am I correct?
You are correct, but there's a huge important difference between the state's statute and the city's ordinances. The city of Vero Beach is using transient in the definition of transient as a means to not allow it to happen in a residential zoning district. The state is using the definition of whether you need to obtain a license or they get essentially their cut of what's going on. So the difference is the state wants somebody to get a license if you are trying to advertise your property and trying to rent it out. Say you're a lousy businessman and you put it on VRBO and you're trying to rent your property throughout the entire year and you don't get one. The city's still going to want you to be licensed for that fact. Whereas the city of Vero Beach, we simply say you can't do it. That's the important distinction between the city and the states.
I'd like to have some background questions if I can.
I'll try my best.
How long has this business been going on where this property is being rented out? Can you tell me that?
No. As far as, hold on one second. I do have to ask a follow-up question to that. I might be able to tell you that. What do you mean by business? I really don't.
Well, I think I consider it a business anytime you rent something out and you get paid for it. That's some kind of a business operation.
Business operation, you mean is how? Are you asking me how long he has been renting his property for 30 days or less?
Yes.
Or
yes.
I don't know the answer, and it's not really relevant to these proceedings either.
It seems. Let me put it to you this way. I don't truly. I'm going to be very confused, and it's easy for me to be confused, and I think it's complicated at best. What I see, though, as a person sitting here, when I came to Vero Beach and I wanted to find out whether I could rent I have a guest house, and whether I could rent my guest house out, I think I would ask the questions of the city to find out what the rules and regulations were. And most prudent people, I believe, would then proceed with some caution if I got negative vibes on that or something saying I couldn't do that. And to proceed without following that up, I think is not prudent.
I'm not disagreeing with you.
Okay.
I think anybody who moves into this city should absolutely do their due diligence and find out what's legal and not legal. However, Tim McGarry is not a judge. He's not a jury. He just merely interprets the code. The code was drafted by the city of Vero Beach. The city of Vero Beach is bound by laws and rules just like you and I are. So therefore, if somebody calls in to Tim McGarry and says, can I do this, can I do that, what he says is not gospel. You have to go to the city of Vero Beach code because those are the laws as written to make a determination whether you are doing something you are allowed to do. The whole point of the arguments I've been trying to make today is that somebody who looks at it says, I'm not allowed to rent to somebody on a temporary basis. I mean, Tim McGarry interprets temporary, at least how I understand it, to be 30 days or less. I interpret temporary 10 years or less. Actually, as an attorney, I interpret anything less than affinity as temporary. True. And think about it in your mind. Don't think about Tim McGarry for a second. Think about it in your mind. If somebody says, you're not allowed to rent your house on a temporary basis, I bet you I'd probably get 3 or 4 different answers.
In the backup material I received, I tried to work with the term transient a lot. Tried to figure it out. And it was at my own home. Maybe I should admit it some ex parte, but I looked up the word transient also to see what it said. And it is an adjective, and it also is a noun. And there's a difference in the definition if you take it as an adjective than you do as a noun. I tried to understand that. What I don't know is all the legal, how far legality, where it begins and where it ends, and I have a difficult time assuming my role in that position because don't have this background.
Can I ask you one question? Sure. If you were trying to regulate rentals for 30 days or less, why don't you just say it? That's not what it says. It says there's a rebuttable presumption that it's transient occupancy. That implies that I can rent it for greater than 30 days and it's transient occupancy, or I can rent it for less than 30 days and it's not necessarily transient occupancy. That's the confusion that exists with this code as written. And the code as written cannot be what you want it to read. It has to read how it actually reads. That's not my words. That's coming right from the 4th DCA. And I don't want to get too much into the legalese about it, but the point is you read the code, you probably wouldn't have much of an understanding of what you're allowed to do if you lived in a residential zoning district.
Mr. Chair, if I may.
Yes.
You bring up a good point about doing due diligence when you move into an area and you want to buy a house or possibly rent properties out, and your first thought process, especially if you've been doing it for a little bit and you have the money to do it, you do call the P&Z department to find out what's going on with the code. And let's say, for the sake of argument, after you hear the interpretation from department head, obviously if you own property and you're a businessman, if you talk to a staff member that's just like let's say a secretary and you don't get the answer you want, you're going to go to the head department head. In this case, it happens to be Mr. McGarry, and ask, okay, what is the interpretation of this code? And let's say, for the sake of argument, the interpretation that the P&Z director gives you don't really agree with. Well, again, being a business person, you would say, okay, I don't agree with you. Then you would take it to the elected officials to challenge that. The elected officials, in our case, they've given the okay for Mr. McGarry to interpret the code. Now, not you personally, but I say you, it could be me. If I don't agree with his interpretation, well, I'll look into it further, then I'll take it before the elected body. But Mr. Chair does, like I said, he brought up a good point. You do your due diligence. Elected officials, they're the lawmakers, and I guess at the end of the day, if you would go before the elected officials, and let's just use what we have on the books here, if they agree with Mr. McGarry's interpretation and the city attorney, let's say, then they're going to keep it on the books. You do your due diligence. So I agree with the chairman's concerns, as far as doing that. Thanks.
If I could just interject, that is why we're here today. It's because there's been an interpretation by the planning director, and the code says that this board reviews those decisions and either uphold or modify or quash his interpretation, basically. So that's why we're here. That is the process, and the next step from here would be the city council.
Wayne, is it possible if I come in, I'm the applicant now, I come in and I'm going to try to rent my guest house out. I have some choices. If I get a negative and I move forward, I'm at my own peril. Is that correct?
Well, certainly. But remember, this is not a fact-based review that you're doing here. You're looking at, you're concentrating on the ordinances, the land use regulations,
itself,
what Mr. McGarry has determined as the interpretation. and you render your decision accordingly based on the arguments you're hearing.
If I may.
That's a little different than I have
Right.
to rethink that a little bit, okay,
Right.
to get it turned around.
If I may, just to inject a point, if Tim McGarry is going to be the sole person to determine the law, then we shouldn't have a code. We should just all go to Tim McGarry. It's that simple.
Well, there's somebody has to be there to be that point person, and then other people will reaffirm or deny his decision, okay?
What if he's wrong? I can be wrong. He can be wrong.
Well, I think,
Everybody
isn't
can
that
be
why you
wrong.
came to this board then next, is to determine whether he made a correct decision or not?
Absolutely.
And
That's why I'm
so
before
our
you.
interpretation is, if it's consistent with his, then we should disagree with your client. If it's consistent with his, then we should agree with Mr. McGarry. Is that correct?
If you uphold his interpretation, yeah, I mean, there's an appeal process above you.
Correct.
It's you don't have to. The point I was trying to make is that his interpretation is not gospel. That's the reason why we had this hearing
We agree.
to begin with, where I put forth the arguments. You have to take his interpretation into mind, our arguments into mind, our interpretation into mind, to come up with an informed decision. There's intelligent people on this board to make the decision. Reasonable minds can disagree. I strongly disagree with Tim McGarry's position for the reasons that I stated, and I ask that you adopt our interpretation of it.
Is there
Okay.
not a, trying to word this correctly, is there not a feeling of guilt when you call the planning director and you get his interpretation?
Mm-hmm.
Is there not a feeling of guilt toward the party renting that what they're doing is wrong, not just under the law, but maybe to their neighbors? Maybe they're creating a problem in that neighborhood, residential neighborhood, and that's why the city has set aside specific areas for rentals and transient rentals.
Well, I think we're confusing what our role in the process is here. The statements that you make would be absolutely relevant for whether to have enacted 2015-02 in the first place. I don't live in a world where I get to say ignore the law because this is the right thing to do, as at least subjectively. Rather, I get to say my role in the process is this is how you wrote the law. I have clients who are trying to follow the law. Your law does not give our clients any direction what to do. Therefore, I have to appeal to you. The point I'm trying to make is that the arguments that I was making is it's very confusing for the people that I work for. Nobody knows what to do. Only people know what to do are the ones that contact Tim McGarry, who says that you can't rent it for 30 days or less, which, by the way, isn't true. That's not what your code says. It's just it's a misinterpretation of the code itself. Rather, my role in the process is like what I said before, is people come in, they have to follow the rules as drafted by, not the people in this room, by the legislature, City of Vero Beach. And once those rules come out, we all have to comply those rules, whether we like them or not. And if the rules do not pass constitutional muster, so to speak, or do not provide enough guidance for the people involved, you can't enforce them. And that's your role today, is to determine whether you can enforce something like this, not whether you are for short-term rentals or against short-term rentals.
Correct.
It's just whether
That's
you
right.
can apply this.
Mike, the comment that this individual probably had the best intentions of renting his unit out on a short-term basis, and they would be wonderful people there, and there would be good neighbors, and et cetera. I don't think that's what's in question. We're not talking about that at all. I think what we're saying here is, did these people follow the rules, and were the rules acceptable or proper, and were they laid out specifically enough that they could understand them? And if they didn't understand them, shouldn't have they got clarity before they proceeded, so that they weren't, and then once they knew that results of that, then proceed or not, or proceed at your own peril. That's where I'm coming into it, because may have liked to rented my guest house out, but I don't believe it's because it's specifically not permitted. I read it when it's not permitted in my neighborhood. Okay, I can let somebody stay there. I can build it. I can use it for my family and friends, but I can't charge them for it. That's my interpretation.
If that's your interpretation, I respectfully disagree. I don't think enough guidance has been provided to say that you can or can't do the thing
And
that
I
you're
think
questioning.
that beyond that, then it's above my level. It's probably, I think the courts are going to have to decide, because I'm just like Mr. McGarry. I have an opinion just like Linda has one, and I saw hers leaning that way, and mine probably leans the same way. But the legal part of this may be a pay grade above me.
I understand.
Okay.
I also feel that Mr. McGarry was hired to make that decision, just as the city council hired our city manager. He is under the bequeath of the city council. Mr. McGarry is under the bequeath of the city council and code enforcement and the planning and zoning board. And we are here to accept his guidance and interpretation of the code as it is. He is the planning director. He is where we go to.
He's our expert.
Correct.
And we kind of accept some of that in a lot of cases, just like we go to our attorney and accept his vision for us because we're representing the city's interest here. If I was out there in the audience, it'd be maybe a different representation, just like you're representing your client.
I understand. My goal today was to ask you to keep an open mind and to listen to my interpretations and arguments. I respectfully disagree with both your opinions. That's all.
Mr. Chairman, unless you have specific questions, I think probably Mr. McGarry's attorney should put on his case.
I do have one. I really liked your analogy about driving through an area and you see a sign that says drive unhurriedly or drive slow. And what does that mean? And what would a reasonable person think? And, well, I don't know. People would consider me reasonable. My first thinking is, what do they mean by this? You know what? I've never seen a sign. Usually you see a speed limit or school zone or something. And so I started thinking about what's reasonable. And you know what? I would ask. I would go and find out what is reasonable. And if I got pulled over and I was traveling and not what was, unhurried, I would say, what did you mean by that sign? So I understand, why you're here. But I'm curious, and I don't know if I'm entitled to this information. When the person decided to rent the house the way it was rented, had he inquired? Did he know that there were rules in place? Am I entitled to ask that?
It really isn't relevant to the question, because all you're looking at is the code, the interpretation code.
Okay.
And what does guest house transient quarters mean? And I think Mr. McGarry's interpretation also went so far as to give an advice as to whether or not that was a permitted use in certain districts.
Okay. I was just following up on what was in the backup.
Another thing to keep in mind is not just the arguments I made about the vagueness, is that the state legislature said that the city's not allowed to do what it did in 509032. It said that you can't.
Unless it preempted it.
Well, it said it preempted it. Just said if you can't do it unless the ordinance is enacted or unless the law was in place prior to June 1st, 2011. This is ordinance number 2015-02. That's 4 years after that rule came in place.
The ordinance that we had in effect prior to that time, aren't all laws and ordinances being tested all the time and modified to meet as the times change? And so shouldn't the ordinance that we had in place be able to be modified as time went on to more specifically identify new things or shortcomings of the particular ordinance?
Well, let me put it succinctly. The state legislature said the answer to that question is no.
All right. Any additional questions of the applicant?
Well, just a comment. As I understand it, part of your argument is saying that precedents that have been set by Mr. McGarry's office are all invalid as it relates to this issue.
What I'm saying is that if you indeed had a valid ordinance or valid code that regulated short-term vacation rentals or guest house and transient quarters, 2015-02 would not have been necessary. But since you lost in court on that issue, you changed it, and the state legislature said you couldn't. It's not a feel-good story or a feel-bad story. It simply is.
So since this issue was decided in court, everything that his office has made a determination on relative to this issue on various cases is unconstitutional and does not apply.
If I understand your question, are you talking about since the 2015 ordinance till present? Yes, it's our argument that everything they have done to this point has been improper. Any citations you received, if the court were to strike it down or determine that it was unconstitutional or unenforceable, you should expect a lawsuit from those people trying to get their money back. That is probably going to happen.
Any other questions, Jonathan? If not, John, thank you.
Thank you.
Planning Director presentation, opening statements. I'm sorry, Nick.
Good afternoon, folks. Nick Zabresny here on behalf of Gary. Zabresny, yes.
Zabresny, okay.
Give me 1 second here to get set up. Good afternoon. I think there's a thing that certainly needs to be clarified before we continue to proceed here, and that is the scope of today's proceedings, why we're here, and really the scope of y'all's inquiry. When an individual receives a citation from a code enforcement officer, they can, pursuant to Section 2303 of the Vero Beach Code, request an administrative hearing in front of the Code Board, contesting that citation. Now, pursuant to that same section, 2303, if that individual wishes to contest the code enforcement officer's interpretation or application of the relevant code provisions, they can appeal the code enforcement officer's interpretation and application to Mr. McGarry. So that is what's really being appealed. It's a decision by Mr. McGarry as to the officer's interpretation and application of the relevant code provisions. Now, once Mr. McGarry issues his decision, which is why we're here today, the aggrieved party can then appeal that decision pursuant to 6404, which says that a person aggrieved by a decision of the planning director may request review of that decision. So the scope of this inquiry is really limited to the decision that Mr. McGarry rendered in reference to that citation. Any arguments regarding constitutionality, vagueness, whether or not there was improper delegation are certainly not proper before this board. It would certainly be something that a court of law would ultimately decide. And I'm not faulting Mr. Rodeback. I will tell you, and there are some case law that might indicate that if a person doesn't at least raise these issues later when they do go to court, they might waive them. So they're trying to preserve a record, and I understand that, but it's not a proper decision for this board to make. It's solely limited in analyzing Mr. McGarry's decision. Now, with that being said, let me also just jump into the Wagner matter, and I know it does get confusing because we have two cases here, but there was one distinction that Mr. Rodeback raised, and that is some notice requirement and the ability to correct a correction period. That, again, is not a matter that's appropriate in front of this board. In fact, while that might be a defense, that is something that will be raised in front of the Code Enforcement Board when the matter's here, and I believe we could even seek guidance from Mr. Clement as to that issue. But again, the scope is limited to exactly what Mr. McGeary's interpretation was, and quite frankly, the decision speaks for itself. It's very clear. It's very easy to follow. And I'm not going to sit here and belabor on a lot of these points that were raised regarding constitutionality, vagueness, First Amendment issues. I will say that the guest house transient quarters definition has existed in the Vero Beach Code since the late 70s. And I will show y'all just by way of an example, because again, I know I don't want to get y'all confused and bogged down into something that we don't need to, but because it was continually raised here today, when we're talking about, and can y'all hear me?
Yes.
Am I being picked up? I want to make sure I'm getting picked up here on the microphone. Let me make sure I can get y'all a copy, but I want to show you Ordinance 2015-2. But if we look in the top guest house transient quarters here, we see no substantive changes. And this is coming from Ordinance 2015-2. This was not changed, anything substantively. While there may have been some other definitions that were added, those definitions are nowhere contained or analyzed in that decision that is subject here today before y'all. So I just want to make sure that we're very clear on that point, and again, the scope of this inquiry. So simply what it comes down to is that use, guest house in transient quarters, a use that is permitted, not only in the R1A district, but in the RM10 district, which is the two districts that we're talking about by consolidating these, but really any residential district. And the fact of the matter, it's not. The code specifically states that. The code specifically delineates that any use that is not either a permitted conditional or special permit use within a specific zoning district it's unlawful in that district. And that was the reason, that was the genesis of the citation to the Wagners and to Mr. Fitz. That is the reason why the code enforcement officer issued a citation, and that is also the interpretation that y'all have before you here today. Now, the decision, again, does not look at any of these 30-day rules, does not interpret any other definition other than guest house and transient quarters, and in fact looks at the plain meaning and the common understanding of those words that are used in that definition, and specifically would be transient and temporary. And it goes at great lengths to show the plain meaning and understanding, especially citing just the Webster's Dictionary. Now, the argument that this decision somehow relied on 509, Section 509.013 of the Florida statutes, I would certainly say is incorrect, because if you look at the clear express language of the decision, it determines, again, based on what the plain language of transient is, based on the Webster's Dictionary and the common understanding, that it is for a temporary brief stay. Then it goes on to say, by way of example. So it's just there as an example, highlighting the conclusion that's already made. In no way, shape, or form does this decision rely on 509. So again, while I would also argue that that is beyond the scope of this inquiry, I want to clarify those minor issues before y'all. As you can see also, I know it was not addressed here in the argument, but Mr. Rodeback's appeal and letter brings up various arguments related to commercial districts and RM13 district. I will say that clearly again, the definition, the decision as to the code enforcement officer's interpretation and application references commercial districts for the sole fact of saying, look, guest houses and transient quarters is not a permitted use in any residential district. However, it is a permitted use in certain commercial districts, therefore highlighting the commercial nature that is inherent in the idea of a guest house transient quarters. Now, I know the argument was made, not today in actual oral form, but if you look at the letter, the appeal, there was an argument that transients were somehow permitted in residential districts due to an RM13 district. I will just inform the board that was actually, to my understanding, a Scrivener's error. That had been removed. That zoning district had been removed a long time ago from the code, except for that heading, which was in the definition section, had not been eliminated. So, guest houses and transient quarters were not permitted in any of the residential zoning districts. I will take a moment maybe to just address a few arguments that were made here. And again, I think we've talked about the preemption, but I do want to let the board know that you may or may not know that there is underlying litigation pending in this case. In that litigation, the court has determined that Mr. McGeary has quasi-judicial immunity for his role during this administrative process as far as issuing his decision regarding the code enforcement officer's interpretation and application of the code provision. So as such, he's prohibited from being compelled as to his thought process, his opinion, decision-making, and also even his knowledge and qualifications in rendering those decisions. So since no witnesses were presented on behalf of either Mr. Fitz or Mr. Wagner, I do not believe, A, it would be appropriate to call Mr. McGeary because any questions really would be limited to the four corners of his decision anyways and would basically be going through step by step as to what that decision says. So I will keep it brief and leave it there. I will bring up one issue regarding, I know, Mr. Cahoy, is that correct?
Yes,
you
sir.
had an question regarding whether or not, since the court, and I believe it was argued in the Carroll case, issued a determination. And in fact, I think it was argued that the court decided the matter and therefore it's no longer in y'all's hands. I will just inform you that the scope of the court, the appeal to the circuit court, is really limited. They're looking at whether or not someone essentially complied with the essential requirements of law during an administrative proceedings and overstepped their boundaries. So the court didn't rule on any substantive merits as to this. It was simply at that time the manner in which the code, the Vero Beach Code, was drafted essentially was not clear enough as to whether or not the Code Enforcement Board had the authority to rule on that issue, and at that time they did, and that was what was appealed. So my understanding is substantively the court made no determination as to anything involving guest houses and transient quarters. But if y'all have any questions for me, I wanted to keep it brief, and I wanted to make sure we just focused on the limited inquiry that's here today before y'all.
I have one.
Sure.
In the other gentleman's presentation, I think he used the word, I wrote it down, maybe I didn't get it correct, but per incurium?
Per curiam.
Per curiam. So what did that mean? I didn't know what that meant.
Per curiam.
You're talking about it right now, I believe. Is that correct?
Well, I will tell you this. There is case law that says per curiam opinions are not binding on other courts of law. I will tell you that I believe there was no actual opinion issued. PCA affirmed it. Per curiam affirmed it without an opinion.
Would you explain that one more time?
So essentially,
it doesn't
and I would actually invite Mr. Rodeback to correct me if I'm wrong, because my understanding is the Fourth District Court of Appeal issued a per curiam affirmance opinion, which means it really just, there was no opinion. They just said matter was affirmed without actually drafting an opinion.
Respectfully?
Yes.
Simplest terms I could put it, we agree.
So there was no actual drafted opinion.
Okay. It's an affirmation, I think. Yeah. Okay.
Took a position
Took
without
a position without
It
an
was-
opinion.
it-
Took a position without an opinion.
But again, without getting into any the legalese behind it, what was being appealed in the appellate process there was really whether or not, as the code was written, whether the Code Enforcement Board, to my understanding, whether they complied with the essential requirements of law.
So it was a narrowed.
It was not
defining
on the merits. And again, I would, if Mr. Rodeback has any other interpretation as to that, he's certainly welcome to get back up here and rebuttal and state that. But
Okay.
Mr. Rodeback talked about the definition, and he stepped it down from top to bottom relative to what does transient mean and so forth. What is your position on definition and how it applies to this?
Well, I will tell you that it's not my position. It's what we're here today
Your
is
argument, excuse me.
looking at the clear, plain. Well, we're looking at Mr. McGeary's decision as to the code enforcement officer's application of these sections of the code. And based on this decision, it shows that the very clear language of the definition, which I will read, guest house and transient quarters, is defined as any structure included converted dwellings in which less than 10 bedrooms, with or without meals, is rented or otherwise provided for compensation to transients for their temporary lodging. And this decision goes into great detail, not only Webster's dictionaries as to transient and temporary, but just common sense, plain meaning. What does transients mean? It's an individual staying somewhere for a short time, passing through or by a place with only a brief stay or sojourn. And it concludes that in the context of this section, transient is a person or guest that is only staying for a brief stay or a short time. So that is what is before this board. And really, ultimately, the crux of what is in front of this board is whether or not the code enforcement officer and then Mr. McGeary's interpretation is correct or incorrect that guest houses and transient quarters are not permitted uses in residential zoning districts. That's plain and simple. That's what the ultimate question is.
Questions?
Mr. Chair, if I may?
Yes.
A question for the attorney that's representing Mr. McGeary. In the backup material that I have, Mr. McGeary sent out a letter July 13, 2015. Do you have that?
I do.
Could you, if you would please, sir, read the first paragraph for the record?
Beginning with this letter?
Yes, sir.
Okay. This letter is in response to your appeal contesting interpretation and application of applicable code provision applied by City Code Enforcement in issuing a citation 15-CE 5521 for violation of sections 60.11 and 6102 for the above referenced property. The following interpretation is rendered under the Planning Director's authority pursuant to 6506 subsection J of the City Code and as the designated administrative authority of the city defined in 2-303 of the City Code.
All right, thank you. And the next thing I wanted you to touch on on page 2.
Sure.
If you would, please. The first paragraph where it talks about the number of days, if you would, for the record, it says, in further example, could you read that into the record?
Sure.
Because it talks about a statute in there.
And I will read that, and I will just say that was what I was getting at previously when I brought up 509.
I understand.
In further example of the meaning of transient, the Florida Legislature in subsection 509.013, subsection 4A, Florida statutes, defines a transient lodging establishment, a unit, dwelling, or building, etc., rented to guests for a period less than 30 days or 1 calendar month, or that is advertised or held out as a place regularly rented for such use and duration. The legislature clearly recognized a period of less than 30 days or 1 calendar month duration is transient in definition, or is transient in nature and thus a brief stay or short time. This legislative intent also comports with the definition, common understanding, and usage of the word transient, the same as it is used in describing the city's guest house and transient quarters land use.
And thank you, sir. And if I could indulge you, 1, 2, 3, if you would please go to the third paragraph.
Sure. Subsection A?
That's correct. And go to the second sentence, please. It says Code Section 60.06.
Yep.
Could you just read that sentence into the record, please?
Absolutely. Code Section 60.06A makes clear that in order to be allowed in a zoning district, it must be specifically listed as a permitted, conditional, or special permit use in that zoning district.
Thank you, sir. And one more, if you go to the last page, please, the back where the signature page is.
Mm-hmm.
If you please go to the second paragraph.
Mm-hmm.
And if it begins, you should.
Yep.
Could you please read that sentence,
You
please?
should be aware that the use guest house and transient quarters, which by definition as well as common understanding and practice is a land use that provides temporary lodging for transients, has been a restricted use addressed in the city's zoning regulations since 1977.
Thank you, sir. That concludes my questions, Mr. Chair. Thank you.
I do have a question.
Sure.
On the state statutes that define transient, is that a new definition or has that been long established?
To my understanding, it's not a new definition, but I can't. I'm not going to sit here and tell you that for certain because I don't know. But I do not believe it is. That's my understanding. And again, that deals with whether or not someone under these circumstances needs to obtain a license in order to rent out their house as a transit lodging facility.
Okay, thank you.
Would you talk about a little bit about the definition of between the two applicants? There's the idea of the one was given a chance to correct, and the date was subsequent to the event.
Sure.
Can you talk about that a little bit more and give us some insight?
Well, what I would state is, and I believe I would ask clarity from Mr. Comment here regarding this, but that is beyond the scope of today's proceeding.
So we should not be considering that today.
The reason being is I'm not saying it is or is not improper, but that would be a defense that would be raised in front of the Code Enforcement Board, and I would ask Mr. Comment's clarity as to that regarding any notice issues.
Yeah, I would have to agree that is something that
Not
can
to
be
be
heard in
considered
front of the Code Enforcement Board. It's not so much germane to the interpretation of the code sections we're talking about.
All right, thank you.
And the reason I say that because I see Mr. Rodebeck is not happy with that. That is not that issue that was raised to Mr. McGeary, and therefore it's not part of his decision. That's in front of this board. The issue of notice, and really, let me just tell you a little background. What happened was it doesn't change. There is no change because guest houses and transient quarters are not permitted in any residential zoning district. We know that. The original citation received by the Wagners had the incorrect zoning district, had them, I believe, as an R1A when they were an RM10. Still not a permitted use in either zoning district. So that is the purpose why it was amended to correct the zoning district.
It was a technical problem?
I would argue that it's a scrivener's error, yes.
Okay. All right.
And I'm not sitting here saying they have no basis to raise that in front of the Code Enforcement Board, but that is not part of this board's inquiry because, again, that is not part of Mr. McGeary's decision.
Additional questions? Seeing none, thank you.
I certainly appreciate y'all's time.
Thank you.
Thank you.
Jonathan, do you have a rebuttal?
Very brief.
Okay.
Speeding. I want you to think about the word speeding. Many of us have gotten speeding tickets. If you notice when you drive by the signs, it doesn't say no speeding. It gives you direction. It says 35 miles per hour, 40 miles an hour, not to exceed 20 miles an hour. Then you go 21, then you're running the risk. Prior to the 2015 ordinance, there was no reference to 30 days or less at all. The first time it popped up was in ordinance number 2015-02, which changed the definition of guest house and transient quarters, among other things, by adding a definition of transient and transient occupancy, which for the very first time regulated the duration, which says you can't rent your property for less than 30 days or less. Actually, big clarification there. A rebuttable presumption that the occupancy is transient if you rent it for 30 days or less. So it's not even necessarily prohibited, just that it might be a guest house or transient quarters. And by the way, if it exceeds 30 days, it still might be a guest house or transient quarters because it doesn't say you can rent your property for greater than 30 days either. Take a look at that in the code. If it's not expressly listed as permitted, it's excluded. That's what 60.06 says. There's nothing in that code that says more than 30 days is permitted in residential zoning districts within the city of Vero Beach. Now, the next point I want to make is regarding acting in conformity with the code. Look at the definition of single-family residential structure, residential use of a structure with one dwelling unit. That's what it's defined as in your code. Residential use can easily be defined as renting out your property. So somebody who does that is acting in conformity with the code. Pertaining to Mr. Zabresny's arguments as they pertain to the Code Enforcement Board being the proper venue to contest the amended citation in the Wagner matter, the Code Enforcement Board is limited to fact-finding. That is what the code says. That's what the code says. They are limited to findings of fact, not application of the law to the facts or application of interpretations to the facts. Rather, on its face, it's invalid. They couldn't make the determination that this law doesn't apply because there's an invalid determination. So if we go before the Code Enforcement Board, the Code Enforcement Board's going to say, I just have to find out whether this amended citation was issued. They couldn't make the determination of whether it's valid on its face or not because that's Mr. McGarry's job. He determines the applicability of the code. That's not my words. That's your City of Vero Beach Code of Ordinances 2-303. And also, if going back to my further point about the preemption argument, prior to 2015, take a look at your own code. You will not see 30 days referenced once, 30 days or less referenced once. It wasn't added until ordinance number 2015-02. That is attempting to regulate the duration of short-term rentals, exactly what the state says you can't do. It's been preempted. It's unenforceably vague, and for those reasons, you should strike down and not strike down the citations that have been issued to my clients. Any questions?
Questions? Thank you.
I do have briefs for rebuttal.
Please come forward then.
Thank you so much.
Get out of your way. Sure you don't mind.
Again, very brief. The point was raised twice by Mr. Rodeback in two different contexts, referring to this 30 days rebuttable presumption. Yet I would note that nowhere, at no time, did Mr. Rodeback cite to any particular page in Mr. McGarry's decision in which he relied on a definition or that 30-day rebuttable presumption. This decision interprets solely the guest house and transient quarters definition. So the arguments related to that are unrelated to this decision and are related to a different definition that is not part of Mr. McGarry's decision. So I want to make sure we're very clear on that point. The second point that I want to make, and it may serve as a rebuttal, but also maybe clarification, when we're talking about what is appropriate in front of the Code Enforcement Board, I'm not saying that the Code Enforcement Board has the authority to interpret or to render a decision as to the interpretation or application. I'm not saying that Mr. McGarry's decision as to the interpretation and application in that particular scenario, the Wagner case, is invalid. I'm saying the defenses as to notice and time for correction with respect to the amended citation are defenses that are appropriately raised in front of the Code Enforcement Board, not this board. So thank you very much.
Do you have a closing argument?
Be the quickest closing argument I ever had.
All right.
State legislature preempted this, so therefore 2015-02 is invalid. It's also unenforceably vague. The reference, it just doesn't even say you can't rent your property for less than 30 days. It says you can't be rented, or it's the intention of the parties that it's temporary, which can mean 30 days, 60 days, 90 days. A person of ordinary intelligence wouldn't know what's applicable. So therefore, the ordinance is invalid, and as such, it cannot, the citations that were issued against our client cannot be valid. Thank you.
and I'm certainly not going to beat a dead horse either, but I will point out what you just heard. The ordinance, the argument was the ordinance is invalid. And again, that is not an inquiry today before this board. This board's determination is limited to Mr. McGarry's decision. And that decision is whether or not guest houses and transient quarters are uses that are permitted within either the R1A or the RM10 district. And as we know, guest houses and transient quarters are not permitted in any residential districts. The RM10, the R1A are both residential districts. For those reasons, and certainly I would reiterate that Mr. McGarry's decision certainly speaks for itself, and there is no reason to invalidate that decision. So thank you very much.
Are there any other rebuttals or summations we want to make? And then seeing none, we'll move on to the next item, which is a board discussion. And we're open for discussion. Go ahead, Ken.
If I could, Mr. Chair, I would encourage the board, because I cannot vote today, to vote to uphold Mr. McGarry's interpretation of what we have on the books. I had some things read into the record purposely so folks that are watching this would understand a little bit. This regulation's been on the books, what I call on the books, since 1977. In Mr. McGarry's first paragraph, he is the designated administrative authority of the city as defined in the section 2-303 of the city code. So the city council, they're the lawmakers. They gave Mr. McGarry the authority to do exactly what he's doing. So I would encourage you to uphold what he has in his backup material. It's very clear and to the point. Thank you, Mr. Chair.
Any other discussion?
Yeah, I find it very significant that a state definition for transient existed. And I think what's important here is that we don't have every different county and city in the state defining it differently, so that there should be one definition only that holds true for everyone. And I also find it very significant that we specifically state that it's not a, if it's not a permitted use, it's not allowed, and that we do find that these are permitted uses in commercial districts. Those are the things that I find very significant right now.
Additional comments?
No comment.
No comment? My comment would be that I think there is a difference in the code, and I think it's between residential usage for guest houses and commercial. I think it's stated, and I do not believe it's permitted use, and I believe the definition of transient is coherent enough that I think Tim made the proper decision in his recommendation on this. So I've kind of made up my mind, and if there's no further discussion,
Just
Tim,
remember,
would you like
you'll need to vote on the two applications separately.
Right. So we'll need a motion
Motions, right?
by a board member that. Can you read it there? How are you going to?
Okay, motion by board member. I move that based on the competent, substantial evidence presented and the applicable code divisions, we affirm the planning director interpretation.
And that's the one you've chosen. Okay.
Yes.
And do we have a second on that?
I'll second.
And Robin second that.
Then I would reference this as the application A15-00002.
Okay.
Okay, is that the right reference?
It's the first
Yes.
case, yes.
But for this one, we have to do it again then, if that's appropriate.
Okay, that's number one.
You want to call a roll?
Mr. Cahoy,
Yes.
Ms. Polinsky,
Yes.
Mrs. Hillman,
Yes.
Mrs. Manous,
Yes.
Mr. Lawfer.
Yes.
Passes 5-0.
We'll need a motion on the second item before us. B.
Okay, I can do that.
You want to do it again?
Yeah, sure. I move that based on the competent, substantial evidence presented and the applicable code divisions, we affirm the planning director interpretation for application number A15-0000003.
I second.
Linda seconded it.
And Mr. Chair, under discussion, I won't go over it again because it's already in the record. I stand by my comments that I made on the first case where the planning director has the authority to interpret the code. Thank you.
Any additional discussion?
None.
I think we can call for a vote then.
Mr. Cahoy?
Yes.
Ms. Polinsky?
Yes.
Mrs. Hillman?
Yes.
Mrs. Manous?
Yes.
Mr. Lawfer?
Yes.
Passes 5-0.
Thank you. The next item today is Planning Department matters. Tim, do you have any of those?
The only thing is we do have 3 items. I believe 3 items will be on the agenda for September 3rd, including another, a different kind of appeal.
Another appeal? And that's for September? Which first
September 3rd, the first
the
meeting.
First one, okay. Any other board member matters? Does there need to come before the board today? Anything you want to bring up, Linda?
No.
No.
I have none. Thank you.
None.
Seeing nothing else before the board, we will close the board meeting. Thank you.